Hello once again and welcome to Employment Hour in 30. John Scholes, Lior Samfiru. Easy to reach out either during the show or otherwise, 1-855-821-5900. And it is simply help@employmentlawyer.ca to reach out through email. We'll get to some phone calls from our radio show in just a bit. Also on the show today, pal, employee rights when a business is sold. This is a question that always comes up, be it through email from this show or on the radio shows as well. So we'll answer that and dig into that as well. First, a week that was. How are you, man?
Hey, John, it's been really good. A lot of busy days in my office because a lot of people are calling. They watch this show, they hear us on the radio, and usually when someone contacts me, they start off with, "I never actually thought I would need you. I was just listening because I was interested," and invariably something happens. They may want to reach out. So the same thing with you. If you have a question, an issue, a concern, something that happened, maybe up until today things were great, but today something happened. Well, don't sit on it, because if you sit on it, you may give up rights that you have. Give me a call, send me an email. We'll give you that contact information throughout the show so that you can connect with me. Workplace rights are quite good. They're comprehensive, they're extensive. The law provides a lot of entitlements. The problem is most people don't know what the law says. They don't understand what their entitlements are. Well, if you watch the show, you should know by now, and we'll continue to inform people. But the week there was, let me tell you about a situation. We often talk about constructive dismissal on the show, and some constructive dismissals are very easy to spot. If your employer reduces your pay by 30%, yeah, that's a constructive dismissal. You don't need to wonder whether that's allowed. It's illegal. They can't do that. But there's constructive dismissals that can be more nuanced and difficult to spot, but they're just as real, and the law provides just as many entitlements in those situations. So let me tell you about a matter that I dealt with this week. I spoke with a lady who had worked for the same organization for about 15 years. She was in an administrative position. She had certain tasks that she did, worked with the same management team for years and years and years. Well, new management came in. And her particular boss, new boss that she had, started taking away responsibilities from her. So even though she was in charge of certain things, now she's not. She was in charge of preparing these types of reports, now she's not. Okay. And slowly but surely, responsibilities were taken away. They weren't really replaced with anything, so she was left there most days kind of twiddling her thumbs, not having much work to do. And she talked to the company about it with her boss, and they said, well, no, that's how we want it. We don't want you to do these things anymore. We just want you to do these other two things. And her impression was that they're just hoping to frustrate her and kind of send her the message that they don't want her there.
Same pay?
Same pay, okay. Same pay, and make her quit ultimately. And she became persona non grata, so to speak. And she contacted me frustrated. She didn't want to go to work and not have anything to do. She also felt a bit embarrassed by this, that the responsibilities that she had were taken away from her. Pay was the same. But here's the thing, John, and I told her this. It's a constructive dismissal still. You had a job. You had certain responsibilities. Now those are gone. You're not doing that anymore. You're left without the same job. You're left without the same responsibilities. You're embarrassed. You're doing things that you're not used to doing. That's a change to the job. That's a constructive dismissal. Your employer is not allowed to change your job, even if it means taking away responsibilities, even if it means leaving you in situations where you're actually doing less work. It's still not something an employer is allowed to do. And if they do that, you have the right, as does this lady, to treat that as a constructive dismissal and say, that's it, I'm not going to do that. I don't want to be in this role. That's not what I signed up for. And leave with your severance. Now, for her, that means over a year's pay. She's been there for about 14 or 15 years. A year's pay is what she's owed. So I'm going to help her get that severance. But it's very important to remember that it's not just the big, obvious changes that result in a constructive dismissal. The big pay cuts, the demotions, the relocation to 100 kilometers away. Those are clear constructive dismissals. But anytime your job really gets impacted, it may well be a constructive dismissal. So if you're ever in that situation, I want you to call me. I want you to email me. I want us to talk about it because you also may be constructively dismissed and have a right to get that compensation.
Yeah, you got to think, how long can she sit around playing with a stapler? I mean, she's going to get bored. But in most cases, it's the other way around. It's when more duties have been lumped on you. You're going, hey, this is twice the job I signed up for. I'm getting no more pay.
Exactly.
But it's weird how it works the other way.
It works the other way as well. And listen, some people may be content to say, hey, if you want me to do less work, I'll do less work. You'll pay me the same. That's on you. But that's still not something an employer is allowed to do. And if the employee doesn't want that to happen, then that could be a constructive dismissal. EmploymentHourTV.ca, that is the place to go to find where you can catch our weekly radio show. We take the phone calls from it and we play them back here and we talk about them. First call of the day is right now.
19 years with a company. I had to take a year off last year to get a new hip put in. I'm 58 years old. I was served with a PIP program, so a performance improvement plan, and they laid out a bunch of markers that I had to hit before a certain date. If I don't get close to those markers, I can be terminated. Whether I will or not, that's coming up, I guess. So I'm curious, what am I entitled to if they say you haven't met your quotas here?
What do you think about that?
Yeah, and I remember this call from our radio show. So first of all, interesting to me is if he, in the not too distant past was dealing with a medical condition, was off for medical reasons, is it possible that his medical condition is still impacting his job performance? Maybe he can't fire on all cylinders. Maybe he's not as quick as fast as he used to be. If that's the case, he needs to tell his employer. Make sure that they understand that to the extent that his performance is lacking, it's not because he's slacking off. It's not because he's not trying. It's because he's still dealing with a medical condition. So it's important for the company to know, because they can't punish you if you're sick. But even if it's not the case, even if his performance is just not where it needs to be, John, after 19 years, there is no way. There's no way he can be let go for cause because of bad performance. He would essentially have to be sabotaging the company on purpose to be allowed to, or for the company to be allowed to let him go for cause. He is going to be owed severance. And I wanted to bring this up here to remind employers and employees that if you're let go for performance reasons, it's going to be very difficult, maybe even impossible, to let you go for cause, i.e. without severance. You can be let go. They can let you go if they're not happy with their performance, but they have to pay severance. After 19 years, let's see what this person is actually owed. It's not going to be a cause termination. So let's plug this information into severancepaycalculator.com. Let's see on the screen right now what he's owed. He's in a technical role, been there for 19 years. He's 58 years old. The company may try to let him go for cause and pay him no severance. You can see on the screen right now he's owed 18 months pay. 18 months pay. And I don't know what his salary is here, okay? Whether he's making $30,000 or $130,000. Either way, it's going to be a significant amount of compensation that he's owed. So the lesson here for this person, for all our viewers, you almost can never be let go for cause because of performance reasons unless what you've done is just completely outrageous.
And what is the obligation if you're on a performance improvement plan? If you do fail up to their standards, can you just get the boot, or they can't do it that quickly?
They can let you go. They can,
right.
Internally, they may want to justify it by saying, we're going to let Bob go because he didn't meet our requirements.
Yes.
But that doesn't mean that because they can justify it internally, they can let him go without severance. So those are separate things. The company may only choose to let you go in certain situations. That's fine. But regardless of when they choose, the law decides whether you get severance, and you're not going to be deprived of severance unless what you did is completely crazy.
If you've never been there, check out terminationquestions.com. You can ask your questions about anything under the employment umbrella, and Lior's team will get back to you with an answer. If it hasn't been answered there already, you can have a look again, terminationquestions.com. First one for the show today, guys. What's the difference between a termination and a layoff? I've technically been laid off. Am I still owed to ask for severance pay, or is it an employer within their right to say no?
So this is a great question. I'm glad we're talking about it on the show, because there is a difference between a layoff and a termination, in the sense that a layoff often is viewed as something that's temporary.
Right.
And so I distinguish between situations that are temporary or permanent. Have you been terminated? In other words, that's it, you're gone, there's no job. Or have you been laid off temporarily, in the sense that the company is thinking or hoping to call you back to work at some point. So that should be the only difference. But we all know, John, that with a regular termination, you get severance. Of course, age, position, length of employment are the factors. You go to severancepaycalculator.com. But let's talk about layoffs. And with the layoff, even if it's temporary, the company is planning to call you back, you still are owed severance. You can still, or at least you have the right to treat that layoff as a termination. Your employer in most cases does not have a right to lay you off temporarily. You don't have to accept it. So bottom line, layoff, yes, you get severance. We know that. We know with termination as well. If you're no longer working for the company, even if it's supposed to be on a temporary basis, in most cases you have a right to treat that as a termination, get your severance.
What if you accept it and say, okay, you can lay me off this one time?
Not good. Very bad idea to do that. So you've accepted you're going to be the team player, I call that sometimes, and you're going to come back after 3 months when they laid you off. The problem with that is you've given them the right to do it again. So I've just said you don't have a right, or the company doesn't have a right to lay you off, but if you've given them that right that first time, they could do it again and again and again. That's a huge, huge problem. But that means that if you've been laid off again, and you come back for a few months, you get laid off for a few months, and round we go.
Now you're stuck.
You're stuck. What are you going to do? You're probably going to end up quitting and getting nothing. So with the layoff, in most cases, you're best off to treat that as a termination.
Again, it was terminationquestions.com. From where we got that question, you can ask yours there as well. 1-855-821-5900 is the phone number. As promised off the top, employee rights when a business is sold. We'll get to the first one. When a business is sold, do the employees automatically get severance?
No. So severance is not paid automatically. You get severance with the sale of a business if you're out of a job. If as a result of the sale, you're out of work.
Your gig is finished.
You're not continuing with the new company. You're out of work. The company sold the business. The employees, or you specifically, are not continuing. Then you get your full severance from the company that sold the business.
The seller.
From the seller. Okay. Again, based on the usual factors, age, position, and length of employment. So if there's a sale, a transaction, as a result of that, you're one of the victims, so to speak. Mm-hmm. You're on the end of not having a job.
Yeah.
You're owed severance at that point, John.
If you're hired, taken on with a new company, say you're there for a week, 2 months, and they can you, now what happens?
Well, the nice thing about it is if the new company hires you,
yep,
they inherit your service. So on day one, if you start with the company on day one with the buyer, you have the full service you had with the previous company.
15 years.
15 years, 50 years,
right,
whatever the length of time is. So if and when they do let you go, when it comes to calculating your severance, you're going to be owed your full severance based on the time you had with the previous company as well. So you may have only worked for the new company for 1 week, but for the purposes of calculating severance, you could be a 15-year employee, as you've said, and that could mean a lot of severance. So if you're continuing to work, they inherit your service, and down the road, you'll get your full severance.
Employee rights when a business is sold. Next stop is what happens to an employee's length of service if they continue working. There you go.
They continue working, service is recognized, and down the road, you're going to get your full severance. That's a really good feature of our laws when it comes to the sale of a business.
Can the new company contract out of that?
That's the problem. So if you're being offered a job by the buyer and they say, hey, come in, you're starting on Monday, you're good.
By the way.
You are good in that situation. Yeah. But if you need to sign an employment agreement, the problem with the employment agreement is the company can contract out of your service for most cases. So even though usually they inherit your service, if you sign an agreement with a new company that says we're not going to recognize your past service, then you've given up that service. So let's think about this. You've been with the company for 15 years, company's bought out, you start working with a new company. You sign an agreement with a new company saying they're not going to recognize your service. They let you go a week later. Now they have to pay you severance based on the time with that company, which could be a week, a month, a year, whatever it is. And you're giving up that 15 years. So you have to be very careful. You always have to be careful when you sign an employment agreement. You have to be that much more careful. If you sign an employment agreement as a result of a sale of a business, you want to make sure you're not signing anything that gives up your past seniority. If the company wants you to sign that, talk to me. There's ways to deal with that. Be very careful.
Well, that was the next question. Doesn't matter if they have to sign an employment agreement. I guess there's other things in there that you should be mindful of as well, not just you're giving up your severance raise.
There always are. You want to make sure you're not accepting something that changes the terms of your employment, that gives the company rights and powers they don't have to, but the money literally is when it comes to your past service. Do not accept something as a result of a sale of a business that gives up your past service.
Business is sold and the employee or the could-be future employee says, you know what, this would be a good time for me to jump ship. I don't want to join the new company. Is that a resignation? How does that work?
So if you have a good reason as to why you're not accepting a job with the new company, maybe the job is different location, different hours, different pay, then you don't have to accept it and you can get your full severance.
Okay.
Full severance from the company that sold the business. If you don't have a good reason, you just decide, you know what, I'll take this opportunity to change careers, go back to school, spend more time with the family, whatever it is, retire, then you still get severance, but you're not going to get your full severance. You're going to get your minimum entitlements only. Either way, though, bottom line, if you're offered a job by the buyer and you decide not to accept it, you will get severance. It's a question of whether it's full severance or minimum severance, and that depends on the reason why you didn't accept.
There you go. You want to reach out anytime, help@employmentlawyer.ca. You can also make the phone number 1-855-821-5900. We'll take a short break and get right into the severance pay calculator upon our return. Stick around. Employment in 30. Lots more to go.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back to Employment Hour in 30. This part of the show, we like to talk about something called the severance pay calculator, which is like, I don't know, like hundreds of thousands of people have used this thing and been shocked, if not had their eyes open, about how much severance they should actually be getting, right?
Yeah, it's a staggering number of people that have used it all over the country, and it works actually everywhere in the country other than Quebec. So it allows anyone and everyone to find out how much severance that they're owed, or if you're an employer, to find out how much severance you have to pay an employee. Very simple. Severancepaycalculator.com. Our regular viewers know this. Our new viewers, check it out right now. Grab your smartphone, tablet, go to severancepaycalculator.com right now, because it's the easiest, fastest, least expensive, because it's free, way of finding out how much you are owed. Once you're there, you're answering 3 questions: your age, your position, and the length of your employment, and you are done. And guess what? It's not a week per year of service. It's not 2 weeks per year of service. For most people, it's a heck of a lot more than that. So check it out yourself. If you're looking at that severance letter, you walked out of the meeting with HR, you're taking that walk back to pack up your office, you need to understand how much severance you're owed. Go to severancepaycalculator.com. Maybe you think you're going to lose your job. There's some rumblings about changes, or you're curious, you're interested to know. It's information that everyone should have. I don't care if you're a senior employee, a junior employee, you've worked for 30 years or 3 months. Severancepaycalculator.com. Check it out for yourself.
We'll run an example through the calculator now. It says 47-year-old Matthew was with the company for 23 years. He was let go without any reason and was given a 10-month severance offer with a 3-day deadline. How about that? His boss said that the package was a good one, and he should accept it before the offer expired. Is he owed more? Matthew's 47, earned $125,000 a year in a professional role.
Well, first thing I have to say is that you need to get your advice from someone other than your employer. Yeah. When it comes to your severance, you cannot take your employer's word for it. Oh yes, this package is good. What do you think your employer is going to tell you? Here's your package, and it's really bad. Yeah. No, they're not going to say that, right? So you have to get advice. It's your job to determine how much you're owed. Because guess what? In this particular situation for Matthew, real story that we took from a case on my desk, not even close to being good. So rather than me tell you how wrong his employer is, let's plug that into severancepaycalculator.com right now so everyone can see on the screen how much Matthew is actually owed. So Matthew is a professional. He's been working for 23 years, 47 years old. He was offered 10 months pay, which his employer said, oh, it's a good offer. Well, Matthew plugged that information to severancepaycalculator.com. You can see it on the screen. 18 to 24 months pay is what he is owed. At his salary level, that's a difference of somewhere between $80,000 to $140,000. That's not a good offer. When your severance falls short about $100,000, give or take from what it is, you don't need to be a rocket scientist to understand that it's not a good offer. That's why the severancepaycalculator.com website is so important. That's how easy it is to use. As quickly as I told you what the result is, it would have been just as quick and easy for you to plug that information in yourself. So check it out.
How about this 3-day deadline his boss is talking about? How about hurry up?
So they're offering him $100,000 plus less than what he's owed, right. But he better accept it within 3 days or else.
I'm good.
No. How about he gets what he's owed and take whatever time he needs to get it? So that deadline means nothing. It's a pressure tactic. Every severance letter has it, and every single person that I've ever spoken to that's seen that deadline felt the pressure. They felt, well, I have to sign it or else. Something bad's going to happen. I'm not going to get it. I'm going to lose money. No. The law determines what you're owed. The company doesn't determine that, and they don't determine that the legal rights expire in 3 days. You have 2 years to pursue those rights. So don't worry about that deadline. Get the advice you need and check out severancepaycalculator.com.
And as well, employmenthourtv.ca is the website for the show, and there you will find to catch our radio show, what station you can catch that on. Phone call number 2 from the show is coming up right now.
I had a soft tissue injury. I was off for about a month, did some, rehabilitation. Went back unmodified, still unmodified, supposed to go back next week, but I don't feel like I'm pain-free and comfortable enough to go back to regular duties. How do I go about remaining on my modified duties because I'm not ready to go back to that?
Enter the doctor's note.
Yeah, exactly. But the thing is, when it comes to your health and your ability to do the work, it's not always an exact science. And that, well, you'll be unable to work for 3 months, 2 days, and 1 hour. It doesn't work that way. Sometimes a doctor may think, well, I think in about 3 months you should be ready. Sometimes you may be ready in 2 months. Sometimes it could be 5 months.
Especially with mental health concerns.
Especially. It's very difficult to tell. So in this situation, she thought she could go back to full duties, after a period of time. Well, if she's not able to, that happens. So what does she need to do? Again, doctor's note. Get a doctor's note saying, no, she is not ready to go back to modified duties. She needs it for another week, another month, another whatever it is. And even at that point, the only thing a doctor can do is evaluate and assess whether she's ready to do it. So an employer has to accommodate, whether it's for a day, for a week, or for a year, as long as it needs to. And what you have to do as the employee to trigger that accommodation is something from a doctor. That's all you need, a doctor's note. If the company refuses, if they say it's been too long, that's illegal. That's a human rights violation. It's a failure to accommodate. So get a doctor's note. Take that accommodation for as long as you need to get better. If your company refuses to accommodate, they're not cooperative, they're not helpful, reach out to me. I'll help you deal with it.
And a quick side note, your employer is also allowed to ask prognosis, not diagnosis, correct?
They're entitled to know for how long you're going to be off or for how long you're going to have duties, not why, not what the medical condition is, not what the treatment is. Those are private, personal things. Your employer cannot ask for that. And if an employer does, you're absolutely well within your rights to say no.
Rights for federally regulated employees. That is coming up after a break. 1-855-821-5900. You'll want to reach out. Lots more Employment Hour 30 is on the way. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Hour in 30. EmploymentHourTV.ca is our website. You want to go there, find the radio show somewhere near you. Well, it doesn't have to be near. It's radio. That's generally how it's worked for the last 100 years. But you can find a station where it's available. We take phone calls from it and play them back here. Call number 3 is right now.
I was working for a company for about 6 years, and I was just let go on Monday. They gave me an email stating that I had 2 weeks in lieu of notice and severance pay of 2 days for each year of service. And I was just wondering, is that enough? I'm 53.
We get that all the time. Federally regulated. People bring that up all
the time. Always. And then it doesn't matter. Okay. Let's start with the idea that federally, provincially, doesn't matter. Your entitlements, your full entitlements if you lose your job are the same. Now, for federally regulated employees, your minimum entitlements may be 2 weeks pay plus an additional 2 days per year of service. But who cares? It's irrelevant. Your full entitlements are much more. We talked about severancepaycalculator.com. Well, It works just the same for provincially regulated employees, which is most of the employees in the province, and it works just the same for federally regulated employees, whether you work for a bank or you're a trucker. This particular person worked trucking. You know, you drove across state lines, border lines, etc. So it works the same. Or you work in the railway companies or other, you know, in radio and TV, John. Either way, federally regulated employees have the same termination entitlements as everyone else.
Gotcha.
So let's plug that into severancepaycalculator.com so we see how it works. Remember, this guy was offered 2 weeks plus another 12 days. Not so good. So let's plug that in, severancepaycalculator.com. So he is in whatever role he is driver, supervisor. It's not going to impact it too much in this case. 6 years of service, 53 years of age, was offered a total of about 4 weeks' pay. Except guess what? We see on the screen he was owed about 8 months' pay. Again, depending on how much he earns, that could easily be tens of thousands of dollars difference. He's federally regulated. He's owed just as much as a provincially regulated employee would get. Severancepaycalculator.com. For him, that's a difference of somewhere an extra 6 months' pay. It's huge.
6 years for 8 months. That's a perfect example of a short-term employee getting, you know, severance, right?
Yes,
right
it's
there.
exactly what it is. 8 months, 6 years. It works just the same, and a lot of people believe, just as you've said, that, oh, I've only worked for a company for a short period of time, a few months or a few years. I can't be owed that much.
Right.
No. Short service employees have significant entitlements, often disproportionately higher than long service employees. Don't believe me? Check it out for yourself.
We'll get to another one from terminationquestions.com that says if a company's payroll is less than $2 million per year, are they exempt from paying their employees severance pay?
I like this question because it's something that a lot of people are confused about. Your minimum entitlements, I want to emphasize this, your minimum entitlements may depend on the size of the company's payroll. But again, that doesn't matter. Yeah. That's irrelevant. Your full entitlements, what the full entitlements you have, which is really all that matters, have nothing to do with the size of the company's payroll, the number of employees of the company, whether they're an international company or a local company. It does not matter.
Gotcha.
So do you get severance even if it's a small payroll? Absolutely. You get the same severance as someone that works for a large company. Again, the factors are age, position, and length of employment. Not the size of the payroll, not the number of employees, not the international magnitude of the company. None of that matters. So you work for a small company, you work in a Joe's grocery store across the street. Again, depending on your age, position, and length of employment, you are owed severance. Check out severancepaycalculator.com. You'll be surprised.
We'll slide in one more quickly here in the last couple minutes. Terminationquestions.com says, I just gave my employer 4.5 years, my notice of termination. However, I just read my original employment contract and discovered that I agreed to a non-compete clause. Is it enforceable?
Probably not. In most cases, non-compete obligations are not enforceable except for very senior roles. Your executives, your what we call fiduciaries, people that are in such an important and senior role in the company that if they went to work for a competitor, it could really hurt their previous companies. But that's not the end of the analysis. Just because it's not enforceable doesn't mean that the company is not going to try to enforce it. And if they do, they'll take legal action against you. So bottom line is, it may not be enforceable, but the real question is, will the company try to enforce it? Will they take legal action against you if, in fact, you work for a competitor? You have to take it seriously. If you don't, you may end up with a lawsuit on your hands. So speak to the company. Maybe they'll release you from the non-compete. Maybe they'll be reasonable. Otherwise, if you sign the non-compete and you work for a competitor, you're taking a risk. Best way to deal with that is negotiate that out potentially. Right. When you sign the employment agreement, or at least negotiate a shorter term, instead of 12 months, 6 months, instead of 6 months, 3 months. But bottom line is, it may well be something you'll have to live with.
So quickly, they can't take you to court. They'll probably lose at the end, but it could cost you a few bucks, right?
They can. And they can take you to court. They can make it expensive and make it a miserable experience. And at some point, you're going to win that battle.
Right.
But the point is, how do we avoid that battle? How do we not get into that fight to begin with? And the best way to do that is to be upfront with the company, to try to negotiate something that allows you to work somewhere else. If you ignore your non-compete, you do that at your own risk.
All right, we are done for another show. You'll want to reach out. A lot of information there. Please follow up. 1-855-821-5900 is the email address anyway. And we mentioned it a few times, ran it through a couple times. Severancepaycalculator.com, the first place you go anytime before you sign anything. And you want to email that as help@employmentlawyer.ca as well. Till next time, Employment Hour in 30. Have a wonderful day.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.